As you've just said, the paper will concern the right of the listener to receive information, ideas, and opinions. It'll consider the way that a democratic interpretation of freedom of expression can modify the meaning and scope of those audience rights. So I'll consider the high regard for such audience-based rights, especially in terms of enabling participation in the democratic process, apparent at the Strasbourg Court under Article 10 of the Convention. But I'll also consider the limitations on such expression accepted at Strasbourg in order to determine the content of audience rights in this context. So by political expression will be meant expression that informs the audience and enables debate on political matters broadly conceived, including matters of general public interest, enabling the audience to make informed decisions on such matters of special significance at election times. As is well established, the term expression in Article 10 covers all sorts of expression, including shocking or controversial material, and all forms of media, including social media, websites generally, or images. So the paper is mainly, but not solely, concerned with the media, since it provides the most obvious way of reaching an audience. Depending on its content, speech is often valued instrumentally, and in particular for the benefits it brings to the democratic participation of the audience. So the importance of political freedom in that sense means that challenges at Strasbourg to laws directly interfering with the rights of the audience to receive information and ideas would be expected to fail where such expression is at stake. But as the paper will demonstrate, interferences with or control over those rights of the audience have in some circumstances been accepted at Strasbourg. So the paper will begin by exploring Strasbourg's general stance regarding audience rights to receive information and views on political matters and matters of public interest. Then secondly, it'll go on to examine state control of political expression, beginning with the Strasbourg stance as to media monopolies, and also taking account of methods used by private companies in relation to online expression to present one-sided political narratives. As I'll explain, challenges at Strasbourg to laws regulating political expression to support plurality would be likely to fail. That's on the basis that states must guarantee the right of individuals and the public at large to have access to a pluralistic media sector. States should also ensure that a sufficient variety of outlets and perspectives provided by a range of different owners is available to the public. On that basis, for example, laws restricting the use of algorithms in social media with a view to ensuring that citizens receive a plurality of views on political matters would also be expected to be less likely to be susceptible to successful challenge at Strasbourg. Then thirdly, I'll go on to examine limitations on audience rights to receive information, beginning with state bars on political advertising. As I'll explain, challenges to such bars may fail under Article 10. Fourthly, I'll go on to examine state laws restraining the spread of apparent disinformation as to various matters, including political matters. And then finally, I'll proceed to consider state interference with forms of extremist expression with political connections in relation to the audience rights in question. As we'll see, the court has accepted an instrumentalist approach to political expression. The Strasbourg stance in this context appears to be taken on the basis that some interferences with expression may be aimed at ensuring the quality of the information that the audience receives and at having an impact on the probable audience responses. So Strasbourg has accepted that some restrictions on political expression are aimed at securing effective participation of the audience in the democratic process. The court seeks to determine whether restrictions on expression do further the quality of audience participation in that process. If the aim of ensuring the effective democratic participation of the audience would, it's considered, not be furthered by the expression in question, even if it could be deemed political, then interference with it can be accepted under Article 10. But, as the paper will explore, such restrictions may encroach disproportionately on expression and may not achieve the end in question. So I'll start by turning to the Strasbourg stance as to audience rights to receive expression enabling democratic participation in general. So as we know, the court has repeatedly asserted that freedom of expression constitutes one of the essential foundations of a democratic society. And it's applicable not only to information or ideas that are favourably received or regarded as inoffensive, but also to those that offend, shock, or disturb. Particular stress has been laid, as in Castells and Spain, on the preeminent role of the press in a state governed by the rule of law, which in its vital role of a public watchdog has a duty to impart information and ideas on matters of public interest which the public has a right to receive. The basic thesis behind this stance is that citizens can't participate fully in a democracy unless they have a reasonable understanding of political issues. Therefore, open debate on such matters is necessary to ensure the proper working of a democracy. That thesis engages the self-government rationale as put forward by Michael John. He considered that the intent of the First Amendment in protecting free speech was to deny subordinate agencies, such as Congress or the President, any authority to abridge the freedom of the electoral power of the people. He explained further that the First Amendment guarantees the political freedom of the American people by ensuring that they're presented with open discussion of all issues, even from unpopular viewpoints. The value in free speech, therefore, he found, is that it produces informed voters. So in that sense, citizens are self-governing. It's also a marked feature of the Strasbourg expression jurisprudence that clearly political speech, which may be seen as directly engaging that self-government rationale, receives a much more robust degree of protection than other forms of expression. There's little scope under Article 10, paragraph 2 for certain restrictions on political speech or on debate on questions of public interest, so the margin of appreciation in those circumstances may narrow almost or entirely to vanishing point. As Strasbourg accepts, the argument from participation in democracy is well established as the most significant of the range of free speech theories. The term democracy or the furtherance of democracy has not been narrowly defined at Strasbourg to include only according value to allowing criticism of the decisions of the particular government in power or of politicians or policies in general. For example, in Sunday Times in UK, the court had to determine whether a given interference with free expression was necessary in a democratic society in relation to expression that wasn't self-evidently political. The case, as I expect many people here know, concerned an interference with an article discussing litigation concerning the marketing of the drug thalidomide to pregnant women, on the basis that the article interfered with the authority of the judiciary as recognised as an exception under Article 10, paragraph 2. Applying the tests of necessity and proportionality, the court found that whilst courts are the forums for the settlement of disputes, that doesn't mean that there can be no prior discussion of disputes elsewhere, be it in the general press or amongst the public at large. Furthermore, it said it's incumbent on the media to impart information and ideas concerning matters that come before the courts, just as in other areas of public interest. It said, again, not only do the media have the task of imparting such information and ideas, but the public also has a right to receive them. The court said that the Thalidomide disaster was a matter of undisputed public concern. It raised fundamental issues concerning protection against and compensation for injuries resulting from scientific developments. The court concluded then that the interference complained of didn't correspond to a social need sufficiently pressing to outweigh the public interest in freedom of expression. So obviously, a breach of Article 10 was found. So the Sunday Times case indicates that audience rights in relation to democratic participation shouldn't be confined only to speech directly linked to the political process. The article in question enabled many facets of the existing law on the subject to be called into question, on which voters and political parties might be expected to take a stance. So I've outlined the general position as regards the importance of expression in allowing the audience to participate in the democratic process. But the court has also recognised that government interference with free expression may be necessary to ensure that the audience is exposed to a plurality of views, and so the means of delivering political expression can be subject to state interference. So on that note, I want to turn to ensuring media plurality, a matter that's now also beginning to be significant in relation to online expression. This matter arose in Central Europa and Italy. In 1999, Central Europa, a new broadcasting station, was notified by the ministry in question that it couldn't be granted an operating frequency because of the lack of a free national frequency. In fact, the frequency wasn't available because the Mediaset Group, Italy's largest television company, had failed to comply with the 1997 anti-concentration law that required it to relinquish one of its 3 national terrestrial frequencies. In late 2008, after years of domestic and supranational litigation, Central Europa was finally granted an operating frequency. But it said that the frequency it finally received was inferior to the one originally contemplated in the 1999 concession, making it difficult to reach large parts of the national territory. So it claimed a breach of Article 10. The Grand Chamber said, concerning pluralism in the audiovisual media, that there can be no democracy. Is that okay?
Yes.
Can you still hear me? I think the camera.
Yes, perfectly. Oh.
Okay, I think the camera might have stopped. Well, I'll continue. I think the camera's.
Except for you, Helen, we're all gonna turn off our video in case it helps.
Okay. Well, look, I'll just continue and see what happens.
Yes, go ahead.
Okay, well, at least you can hear me. At the moment, the camera's frozen, but I'll proceed. So anyway, the Grand Chamber said that it's of the essence of democracy to allow diverse political programs to be proposed and debated, providing they don't harm democracy itself. The audiovisual media, it found, have a particularly important role in this respect. It found that a situation whereby a powerful economic or political group in society is permitted to obtain a position of dominance over the audiovisual media and thereby exercise pressure on broadcasters and eventually curtail their editorial freedom undermines the fundamental role of freedom of expression in a democratic society as enshrined in Article 10. The court therefore found that in such a sensitive sector as the audiovisual media, in addition to its negative duty of non-interference, the state has a positive obligation to put in place an appropriate legislative and administrative framework to guarantee effective pluralism. That had not occurred, and that was the basis on which a breach of Article 10 was found. A similar approach could now be taken to monopolies and use of algorithms in relation to the global tech companies owning Facebook, Google, etc. Not only do they dominate the market, but algorithms can be used in a manner that inhibits the receipt of a plurality of views by users. Certain political stances are allowed to gain dominance. For example, in the UK, sometime before the vote on Brexit, a company called Cambridge Analytica, a data processing company, collected data from Facebook, which enabled the Vote Leave campaign to target swing voters, especially people not on the electoral roll because they don't normally vote. So those voters were not fully presented with a plurality of views as to Brexit. Cambridge Analytica used algorithms with particular variables such as location in order to determine which voters the Leave campaign should target to garner maximum benefit. The problem was that there was no legal framework preventing the sustained targeting of certain voters to present a one-sided political story. Thus, the Online Safety Bill introduced in the UK in 2021 is intended to place a duty on the tech companies to ensure that the democratic process is protected. So practices which allow certain political stances, as in the Cambridge Analytica instance, to dominate are intended to be barred. Bars on media monopolies and on certain uses of algorithms have a clear connection with protecting audience rights to receive a plurality of information and ideas linked to the democratic process. But I'm about to turn to bans on political advertising, which I suggest have a more problematic connection. Despite what I've said as regards audience rights to receive information and ideas, including at election times, they've been denied in some states based on the need to ensure the non-dominance of campaigning groups in the democratic process. VGT and Switzerland concerned a ban on political advertising in relation to animal welfare, but that ban was found to fail to satisfy the demands of proportionality under Article 10, paragraph 2 at Strasbourg. In particular, the court said that a prohibition of political advertising, which applies only to certain media and not to others, doesn't appear to be of a particularly pressing nature, and so found a breach of Article 10. So the same might be expected to have been found in Animal Defenders and the UK. The claimant was a non-profit company that campaigns against the use of animals in commerce, science and leisure, seeking to achieve changes in law and public policy and to influence public and parliamentary opinion towards that end. In 2005, the claimant had launched a campaign with the object of directing public attention towards the use of primates by humans and the threat presented by such use to the survival of primates. It was intended to include an advertisement on television. But Section 321 of the Communications Act imposes a bar on political advertising in television or radio. Due to the ban, the advert couldn't be broadcast. The ban was said by Animal Defenders to be incompatible with Article 10, as imposing an unjustified restraint on the right to freedom of political expression. Both the parties in the domestic proceedings in the House of Lords accepted that the only issue of dispute was whether the restriction was necessary in a democratic society. The House of Lords went on to find that the fundamental rationale of the democratic process is that if competing views, opinions, and policies are publicly debated and exposed to public scrutiny, the good will over time drive out the bad and the true prevail over the false. So it said, it must be assumed that given time, the public will make a sound choice when, in the course of the democratic process, it has the right to choose. But the court said that it was highly desirable that the playing field of debate should be, as far as practicable, level. Hypothetical examples, it said, of a non-level field would spring readily to mind, such as adverts by well-endowed multinational companies seeking to thwart or delay action on climate change, or adverts by wealthy groups seeking to ban abortion. The House of Lords noted that in Murphy and Ireland, the European Court of Human Rights had observed that there appeared to be no clear consensus between member states as to the manner in which to legislate for the broadcasting of religious advertisements. The same, it said, could be found of political advertising. It said that while the laws of some states, notably the Scandinavian states and Ireland, appeared to resemble those of the UK, the laws of some other states did not. The court pointed out that the Strasbourg Court has regarded such a lack of consensus as tending to widen the margin of appreciation enjoyed by member states, citing Petrovich and Austria. So it found that there was no settled practice among European states and so determined that each state is best fitted to judge the checks and balances necessary to safeguard, consistently with Article 10, the integrity of its own democracy. For those reasons, the House of Lords concluded that the ban on political advertising was necessary in a democratic society under Article 10(2) and so compatible with Article 10. The claimant took the case to Strasbourg and it was subsequently heard by the Grand Chamber. The dispute between the parties, it found, centrally concerned the question whether the interference was necessary in a democratic society. The applicant's main argument was that the prohibition on paid political advertising was too wide to be proportionate for a number of reasons. A prohibition distinguishing party politics and public interest social advocacy would, the claimant argued, be principled, feasible and proportionate. The wide definition, unjustifiably, it argued, restricted the ability of small campaign groups to engage with the public on matters of general interest. It created a monopoly in favour of established political parties who had access to the broadcast media via free party political and party electoral broadcasts. The prohibition, therefore, it argued, distorted public debate. Animal defenders also argued that the different approach to the broadcast and other media was unproven, inexplicable, and unnecessary. The court said that a narrow margin of appreciation would be conceded. The margin was, the court said, narrowed by the strong interest of a democratic society in the media exercising its vital role as a public watchdog. Freedom of the media, it said, affords the public one of the best means of discovering and forming an opinion of the ideas and attitudes of political leaders. It went on to find that it was incumbent on the media to impart information and ideas on subjects of public interest and that the public has a right to receive them. The core issue, the court said, was whether in adopting the ban and striking the balance it did, the legislature had acted within the margin of appreciation afforded to it. The justification offered by the government included the need to protect the electoral process as part of the democratic order, and they relied on Bowman and the UK, in which the court had accepted that a statutory control of the public debate was necessary given risks posed to the right to free elections. It had said it may be considered necessary in the period preceding or during an election to place certain restrictions of a type which would not usually be acceptable on freedom of expression in order to secure the free expression of the opinion of the people in the choice of the legislature. The applicant contested the relevance of that case as it concerned a restriction on expenditure which only operated prior to and during elections. But the court found that while the risk to pluralist public debates, elections, and the democratic process would evidently be more acute during an election period, the Bowman judgment didn't suggest that the risk was confined to such periods, since the democratic process is a continuing one to be nurtured at all times by a free and pluralist public debate on political matters. It said that in Centro Europa, which I mentioned earlier, the court had not suggested that the recognition of a positive obligation to intervene to guarantee effective pluralism in the audio-visual sector was limited to a particular period. It said that there's a wealth of historical, cultural, and political differences within Europe, so it's for each state to mould its own democratic vision. The state must, the court found, therefore be accorded some discretion as regards this country-specific and complex assessment as to safeguarding its democracy. The court said it was therefore required to balance, on the one hand, the applicant's right to impart information and ideas of general interest which the public was entitled to receive, with, on the other, the authority's desire to protect the democratic debate and process from distortion by powerful financial groups with advantageous access to influential media. The issue to be resolved, then, the court said, was whether the present prohibition had gone too far, having regard to its objective and to the margin of appreciation afforded to the respondent state. The ban, the court found, was the culmination of an exceptional examination by parliamentary bodies as well as courts of the cultural, political and legal aspects of the prohibition, and all the bodies had found it to have been a necessary interference with Article 10. The court said that it attached considerable weight to these exacting and pertinent reviews by both parliamentary and judicial bodies, finding that the bar was necessary to prevent the distortion of crucial public interest debates and thereby the undermining of the democratic process. In addition, the court considered it important that the prohibition was specifically circumscribed to address the precise risk of distortion the state sought to avoid with the minimum impairment of the right of expression. It only applied to broadcast advertising, so a range of alternative media were available to the applicant. The court also emphasised that there's no European consensus between contracting states on how to regulate paid political advertising in broadcasting. It reiterated that the lack of a relevant consensus could speak in favour of allowing a somewhat wider margin of appreciation than that normally afforded to restrictions on expression on matters of public interest, citing Hurst and UK. Bearing those arguments in mind, proportionality demands were found to be satisfied. No breach was found. So we can see that audience rights to receive information relevant to the democratic process can be circumscribed at Strasbourg by the competing demand to ensure that a plurality of views are heard. But the applicant's point in Animal Defenders that a distinction could be drawn between small campaigning groups and party political advertising didn't gain much purchase in the decision due to the margin conceded to the state, which was widened due to the reliance on consensus analysis. I want to turn to some similar considerations in relation to state bars on promulgating disinformation. The courts confronted a number of instances in which statements of possible public interest value or value in relation to the democratic process are alleged to have been untrue, and has tended to concede quite a wide margin of appreciation in such circumstances to the state. Such an instance arose in Delphi and Estonia. The case concerned an internet news portal run by Delphi, which had allowed comments on an article alleging corporate malpractice on the part of a particular company. The article attracted many comments directed at one of the company's directors. About 20 of them contained personal threats, including death threats and offensive language. But the key issue concerned that of defamation. The Grand Chamber found that Delphi's rights under Article 10 had been interfered with since it had been found liable in respect of the comments posted by third parties. The question was whether the interference was justified under paragraph 2 of Article 10. The Grand Chamber considered a number of factors. It said an internet news portal is a publisher. The main difference, it said, between such a portal and the traditional print media is the ability for third parties to post comments on the platform. To that extent, therefore, the Grand Chamber found that an internet news portal's duties and responsibilities may differ from those of the traditional print media, but also from those of social media platforms such as Twitter or Facebook. The findings didn't concern such platforms since they don't provide any content of their own. The Grand Chamber went on to assess the necessity and proportionality of the restriction at issue. There was no dispute that a number of comments posted by readers in reaction to the article published on the applicant company's internet news portal were of a defamatory nature, so there was a need to accept a legal response to them. The question was whether the response satisfied the demands of proportionality. In looking at that, the Grand Chamber considered a number of factors. As a professionally managed and commercially driven company, Delphi had sought to attract comments and had a moderation system in place. The Supreme Court of Estonia had not found Delphi liable for failing to prevent the publication of the comments, but for failing to remove them without delay after their publication. Although Delphi had put in place a notice and take down mechanism and used a filter, the filter had been insufficient. Two convention rights were at stake, Article 10 and Article 8. Therefore, the margin of appreciation to be conceded was the same as to both articles. In that situation, the Grand Chamber impliedly deferred to the interpretation adopted by the Estonian Supreme Court in balancing the two articles against each other. In effect, a hidden margin of appreciation was granted to the highest judicial body in the member state in question, as I suggest also occurred in Animal Defenders, on the basis, in this case, that it had conducted a balancing act between freedom of expression and protection for reputation, with which the Grand Chamber showed reluctance to interfere. So, given the margin conceded, the review was fairly light touch. It was found that the impact on Delphi of the interference was not deemed to be very significant, and that Delphi could have anticipated the comments and put in place a more effective filter. So, the interference in question was found to be proportionate to the aim pursued under Article 10, Para 2. No breach was found. Groups campaigning for audience rights to receive information found that the decision set a deeply troubling precedent for freedom of expression online, partly because the Grand Chamber confined its findings to internet news portals. That created a distinction between such portals and internet giants such as Facebook or YouTube. It placed more onerous duties and responsibilities on such portals as regards defamation than on those social media platforms, meaning that audience participation in online debates would be more limited in relation to such portals, which include online commenting forums forums run by newspapers or broadcasting. The decision also didn't differentiate clearly between comments that amounted to hate speech and comments that may have been defamatory, but could also have amounted to a true reflection of corporate malpractice, a matter of significance to legislators and voters. That decision can be compared with Brzezinski and Poland in 2019. In 2006, Brzezinski was running for local elections in a city in southern Poland. As part of his campaign, he published an election booklet criticizing members of the local government. The booklet discussed poor local water and sewage systems and criticized the mayor of the town for implementing unfavorable contracts with a water company. The booklet also criticized another local councillor for having received municipal subsidies for a company she managed. Brzezinski gave out the booklets to churchgoers leaving a local Sunday Mass. The mayor and the councillor sued Brzezinski and sought an order to prohibit further dissemination of the booklet under Section 72 of the Polish Local Elections Act. Under the Act, a court could issue an order banning campaign material containing false information and had to make such a determination within 24 hours of receiving a complaint. The court found that the booklet was malicious, harmed the mayor's and councillors' reputations without any factual basis, and exceeded the limits of permissible campaign speech. The court ordered Brzezinski to stop the dissemination of the booklet and to publish an apology stating that he regretted publishing untrue information that could have misled the public. He was also ordered to donate to a charity. Brzezinski submitted a complaint to Strasbourg claiming a violation under Article 10. The Strasbourg Court unanimously ruled in favour of Brzezinski after applying the test under paragraph 2. The court determined that the Polish courts had interfered with his rights to free expression when they ordered him to stop the dissemination of the election booklet. The focus of the case was on whether the interference with his right of freedom of expression was necessary in a democratic society. The court took into account the political context of the case and reiterated the importance of protecting political speech, particularly of opposition parties, during elections. The court found that the case concerned a matter of undoubted public interest, local government management. The court reiterated that under Article 10, there was little room for restrictions on such public interest expression, so the elected officials targeted were subject to wider limits of acceptable criticism, and that, as Brzezinski was speaking as an election candidate, the government's margin of appreciation for restricting such expression was found to be very limited. The court then reviewed the Polish court's decisions and, in strong language, it noted that the applicant's statements had been immediately classified as lies by the Polish courts, and it didn't appear from the reasoning of the domestic courts that they'd examined whether the impugned remarks had a sufficient factual basis. The court considered that the applicant was clearly involved in a public debate on an important issue, and the court was unable to accept the domestic court's view that he was required to prove the veracity of his allegations. By following such an approach, the domestic courts had effectively deprived him of the protection of Article 10. The court further noted that the speech in the booklet was not insulting, but within the limits of exaggeration and provocation usually allowed in political debate at local level. The court also condemned the penalties imposed. The court determined that the cumulative application of the sanctions would be likely to produce a chilling effect on political speech. So the penalties imposed were not deemed to be necessary and proportionate under Article 10, paragraph 2. So the decision applied the proportionality test in a strict fashion. But had the domestic courts weighed up the key factors at stake in a more balanced fashion, as in animal defenders, examining the demands of necessity and proportionality in much more depth, but still arriving at the same conclusion, it's possible that the court would have found no breach. On the other hand, the decision did take account of the clear political context, refusing to find that an interference with political expression was necessary in order to safeguard the democratic process. The decision can be compared with the following case, which took quite a light touch approach to the proportionality analysis, where the political context was less apparent. The case is Movement Raelian in Switzerland. It concerned the Raelian movement, which intended in Switzerland to embark on a poster campaign about apparent messages from extraterrestrials. The posters gave the address of its website, the Raelian website. The movement promotes a form of global political union governed by the most intelligent members of society. It also promotes sensual meditation, but those matters were not apparent from the posters themselves. The campaign was disallowed on the basis that it created a threat to public order and was immoral, since it promoted the website, which itself could have offended religious beliefs and possibly led to sexual abuse of children. The Grand Chamber, by 9 votes to 8, found no breach of Article 10. It found that a distinction must be drawn between the aim of the association and the means that it used to achieve that aim. The Grand Chamber noted that a wider margin of appreciation was generally available in matters liable to offend intimate personal convictions within the sphere of morals or religion, citing Murphy and Ireland. It went on to find that the nature of the speech at issue was more commercial than political. Accordingly, the court said that it might perhaps have been disproportionate to ban the association itself or its website, but instead to limit the scope of the impugned restriction to the display of posters in public places was a way of ensuring the minimum impairment of the applicant association's rights. The court reiterated that the authorities are required, when they decide to restrict fundamental rights, to choose the means that cause the least possible prejudice to the rights in question. In view of the fact that the applicant association was able to continue to disseminate its ideas through its website and through other means, such as distribution of leaflets, the impugned measure could not, it was found, be said to be disproportionate, despite the breadth of the law in question. An important dissenting judgment was handed down by Judge Pinto, which would be applicable to expression of greater public interest that might include disinformation, but might also contain truths. He said that a distinction between purely commercial speech and commercial speech with political overtones should be drawn. The apparently generous standard of margin of appreciation should not, he said, be applied without drawing that distinction. The very purpose of Article 10, he said, was to preclude the state from assuming the role of watchman for truth and prescribing what's orthodox in matters of opinion. The state, he said, must strictly adhere to the principle of content neutrality when it decided how to make a public space available. Such prohibitions, he said, are not compatible with the pluralism inherent in democratic societies where ideas are freely exchanged in a public space and truth and error emerge from an unrestricted confrontation of ideas. So he made an important point in relation to measures intended to prevent misleading or possibly false information. I want to turn finally to somewhat similar restrictions on speech that may have political or public interest content, but is deemed extreme, and the response at Strasbourg. So-called extremist expression is usually related to ideas that may be turned political and could potentially make a contribution to democratic debate. But challenges to interferences with extreme expression may fail under Article 10, paragraph 2, or may not be considered at all under Article 10 after being declared inadmissible due to the provision of Article 17, as I'll explain. Various views have been expressed as to whether or how far extremist expression aids audience participation in the democratic process. Extreme expression, such as attacks on particular religious groups, could count as forms of political speech as found in Canusky in France as contributing to debate, even though such expression may offend religious feelings or possibly challenge other substantive norms, such as the equal worth of all citizens. Further, speech from such individuals which avoids incitement to violence but attacks democracy could also be accorded weight on grounds of contributing to debate. For example, certain speakers advocating anti-democratic positions, such as that Islam is incompatible with democracy or that Muslims should not vote since candidates are usually unbelievers, could be defended in stable democracies, Heinze has argued, in principle, as the communication of a minority opinion and thus as a contribution to self-government, where it doesn't carry an actual or implicit threat of violence against others, and where plurality of debate is assured. The work of Robert Post in particular would also combat the conclusion that deterrence of some types of extreme expression could be open to justification. Starting from a definition of democracy as active and mediated self-rule by citizens, Post's view is that each person must have the warranted conviction that they are engaged in the process of governing themselves. A vital component of this conviction, he finds, is that each individual has the potential to influence the outcome of public discourse through her ideas and arguments formed via plural debate, ensuring the democratic legitimacy of decision-making. So on that view, the self-government basis of public discourse dictates, due to collective self-determination, that the rights of the audience to receive information and ideas must trump claims from groups whose feelings are injured by speech. On Post's view, each individual is required to demonstrate a degree of fortitude and self-confidence in order to enter the arena of public discourse unaided by the state. So bearing those views in mind, I'm now turning to the response of the Convention and the Strasbourg Court to extremist expression with some political content. Where such expression is at issue, it would potentially fall within the scope of Article 10 unless Article 17 applies, since, as is of course well established, political expression can include disturbing or even discriminatory material as found in, for example, VBK and Austria. But the role of Article 17 must be considered, since it's of significance in relation to expression often attacking minorities. The article disallows convention protection to certain groups or individuals in providing that there's no right to engage in any activity aimed at the destruction or limitation to a greater extent than the Convention provides of any of the rights or freedoms. In relation to Article 10, that means that a group or individual found to be seeking a limitation of the right to a greater extent than Article 10, Para 2 provides would fall outside the protection of Article 10. Article 17 reflects in this context an acceptance of limitations on speech, where its impact undermines the consequentialist justifications for its own protection. In other words, where a speaker is deemed to be using expression to undermine the values guarded by the Convention, the protection of Article 10 won't apply to the expression. This approach, setting limits to the protection provided by Article 10, differs from the limits provided for under Article 10, Para 2. If expression is deemed to be apt to undermine the fundamental values of the Convention, the tests of necessity and proportionality won't be applied, because where Article 17 applies, the application would be found to be inadmissible. In this context, the Strasbourg Court has tended to see speech as a public interest able to be justified instrumentally by reference to its beneficial effects on democracy due to its effect on the audience. That stance renders speech vulnerable to arguments contrary to Post's view that it should be overridden by competing public interests, which could be deemed also to be essential to the maintenance of democracy. Insofar as the court sees the value of free speech mainly in terms of its contribution to the political process, it could, and does, in accordance with Article 17, approve an argument that allowing the speech in question will do more harm than good to the maintenance of democracy in terms of the impact on the audience. That stance may be taken on the basis that some extremist expression, whether from far-right secular groups or speakers inspired by ISIS or similar groups, has counter-democratic aims, or on the basis that while a group using terrorist methods may not ultimately oppose democracy, the methods used in themselves may circumvent the democratic process. In a number of decisions, therefore, the Strasbourg Court has refused to offer protection to speech supporting terrorism or attacking racial or religious groups relying on Article 17. For example, in Girard in France, the applicant had been found guilty of disputing the existence of the Holocaust in his book. He received suspended sentences of imprisonment and large fines. He argued at Strasbourg, seeking to rely on Article 10, that his book was a political work written with a view to combating Zionism and criticizing Israeli policy and had no racist or anti-Semitic content. The court found, as the domestic courts had accepted, the applicant had adopted revisionist theories and systematically disputed the existence of the crimes against humanity which the Nazis had committed against the Jewish community. The court found that the message of the book was incompatible with democracy and human rights, and that its proponents indisputably had designs that fell into the category of prohibited aims under Article 17. The court found, therefore, that the message of the applicant's book ran counter to the fundamental values of the Convention, so the application was declared inadmissible. Similarly, in Pavel Ivanov and Russia, a speaker who had attacked Jews was found to be unable to rely on Article 10, since again his expression was found to fall within Article 17. He'd been charged with public incitement to ethnic, racial, and religious hatred through the use of the mass media. The prosecution's case was that the applicant, through a series of publications in his newspaper, had called for the exclusion of Jews from social life, alleged the existence of a causal link between social, economic, and political discomfort and the activities of Jews. The claim was again found to be inadmissible. A similar result was reached in Mbala in France. The court found that a French comedian's show was a demonstration of hatred, anti-Semitism, and support for Holocaust denial. The court considered that even if it was meant to be satirical, it didn't fall within the protection of Article 10 under Article 17. Article 17 was also relied on to effect this exclusionary approach in Nouët and UK in relation to an expression of anti-Muslim sentiment. The applicant, supporter of a far-right party, had displayed a poster stating "Islam out of Britain" and a picture of the Twin Towers in flames. He was convicted of a public order offence. Inadmissibility of his claim was found to arise, although the expression was unlikely to inspire violence, because it linked Muslims as a group with a grave act of terrorism and was incompatible with convention values stated to be those of tolerance, social peace, and non-discrimination. A somewhat more readily defensible reliance on Article 17 arose in Belkacem in Belgium, an Article 10 claim from a Salafist preacher convicted of offences relating to incitement to violence against non-Muslims, which was declared inadmissible. The court, however, elided the application of Article 17 to incitement to violence, defending Sharia while calling for violence to establish it could be regarded as hate speech, with a statement of much more general import. Each contracting state was entitled to oppose political movements based on religious fundamentalism. A somewhat similar stance was taken in ROJ TV in Denmark. Under Article 17, the court rejected the application by the Denmark-based TV company ROJ under Article 10 on the basis that it was convicted and deprived of its license because some of its programs were considered to have promoted the Kurdistan Workers' Party, PKK, listed as a terrorist organisation in the EU and elsewhere. The court reiterated that Article 17 is only applicable on an exceptional basis and in extreme cases, citing Perensek and Switzerland. In the present case, however, the court attached significant weight to the fact that the City Court of Copenhagen had found that the one-sided coverage with repetitive incitement to participate in fighting with the organisation in question had amounted to propaganda for the PKK. In these instances, then, reliance on Article 17 obviously precluded an application of the tests under Article 10, paragraph 2. But in the following instances I want to consider, Article 10 was considered in relation to extreme speech, but no breach was found since a weighty justification for the interference was identified. Such a justification was identified in respect of one form of extremist speech in preference to relying on Article 17 in Västergötland and Sweden. The applicants had distributed homophobic leaflets in a secondary school, resulting in their convictions for agitation against a national or ethnic group. The school setting, it was found, militated in favour of finding that the interference with their activities was justified, given the unacceptability of homophobic expression in a democratic society. A somewhat similar stance was taken in the domestic case of Salman Butt, in which Article 17 was again not relied on. Butt had been listed as an extremist speaker by the Home Office, which had meant that some potential invitations to him to speak in universities may have been decided against, although there was no evidence that he had been de-invited. His listing was based on guidance on the operation of PREVENT in universities. PREVENT is a counter-terrorism measure, a program designed to identify persons at an early stage who are at risk of being drawn into terrorism and enable intervention. It affects speakers in universities and schools. Extremist speakers whose speech may draw persons into terrorism should not be invited under the guidance unless balancing speech can be made available. Salman Butt claimed under Article 10 that the guidance was not a necessary measure in a democratic society since it was intended to prevent people being drawn into non-violent as well as violent extremism. That argument regarding Article 10 was rejected in a significant judicial exposition of the links between terrorist violence and extremism. Non-violent extremism, it was found, could be characterized as promoting hatred and division, encouraging isolationism at one with a rigid version of religion or ideology capable of justifying violence, since those persuaded by the expression might reject the democratic means of effecting legal change. Inclusion of such extremism as extremist expression was therefore found to be rationally connected to the aim of protecting the rights of others under Article 10, Para 2, to be free from threats of violence, so no breach was found. A somewhat different example, but also concerning anti-democratic methods of effecting change, is provided by the Brind case. In the domestic case of Brind, it was found that preventing IRA-supporting politicians from speaking directly on air by using actors to dub their voices didn't violate free speech principles because the content of the speech wasn't affected, merely the manner of its delivery. It did mean that certain historical speeches from such politicians couldn't be broadcast in their own voices. The basis for the ban was that the politicians in question had supported terrorist attacks. Brind's claim at Strasbourg for a breach of Article 10 then failed. The Commission found in the circumstances of the case, bearing in mind the margin of appreciation permitted to states, the limited extent of the interference with the applicant's rights, and the importance of measures to combat terrorism, that it couldn't be said that the interference with the applicant's freedom of expression was disproportionate to the aim sought to be pursued. The claim was found to be manifestly ill-founded. But a more general argument for disallowing airtime entirely to the speeches of such politicians, stifling their ability to use a very significant medium to promulgate their message, would have failed under the application of this justification, bearing in mind that the IRA was not attacking democracy per se. In the following instances I want to mention, Article 17 was not found to apply, so Article 10 was considered and was found to be breached in relation to some forms of extremist speech. For example, in Erkaban in Turkey, during a local election campaign in 1994, the applicant gave a public speech in southeast Turkey. More than 4 years later, criminal proceedings were brought against the applicant for having incited the people to hatred or hostility through comments made in his 1994 speech about distinctions between religions, races, and regions. For example, he described all parties except his own as parties of the unjust, lovers of the infidel. The court found tolerance and respect for the equal dignity of all human beings constitute the foundations of a democratic, pluralistic society. So as a matter of principle, it may be considered necessary in certain democratic societies to sanction or even prevent all forms of expression which spread, incite, promote, or justify hatred based on intolerance, provided that any restrictions imposed are proportionate to the legitimate aim pursued. In that instance, due to the importance of protecting political expression, especially that of a politician, and due to the harshness of the penalty, the demands of proportionality were not found to be satisfied, so a breach was found. A similar conclusion was reached in Gündüz in Turkey. Gündüz, who had spoken very critically of democracy, describing contemporary secular institutions as impious, was convicted of religiously based hate speech. The court found a violation of Article 10, finding that the applicant had been taking part in a pluralist debate seeking to present unorthodox views, including the notion that democratic values were incompatible with one conception of Islam, a topic debated widely in the media rather than amounting to a call to violence or to hate speech. A somewhat similar approach was taken in Perrin-Czech in Switzerland, in which the Strasbourg Court didn't give the same protection to denial of the Armenian genocide as it had afforded to Holocaust denial. The Grand Chamber took a range of historical factors into account in finding a breach of Article 10 due to the conviction of the applicant for denial of Armenian genocide. The court also analysed whether other state parties criminalised the denial of such historical events. Data revealed that Austria, Belgium, France, Germany, the Netherlands and Romania criminalise only the denial of the Holocaust and Nazi crimes, while 12 states criminally sanction the denial of any genocide. So 18 states criminalise denial of certain historical genocides, not a majority of the contracting states. Despite a degree of consensus, the court found that Switzerland stands at one end of the comparative spectrum as it criminalises the denial of any genocide, without the requirement that it be carried out in a manner likely to incite violence or hatred. Further, a lesser sanction could have been imposed. A breach of Article 10 due to the disproportionality was found. So to sum up as regards Strasbourg's approach to extremist speech, the broad exclusionary approach taken in the cases in which Article 17 was found to apply could be defensible in a number of instances where a clear link with incitement to violence or support for terrorism was found. But the court's approach is open to criticism as failing to confine itself clearly to expressions of support for violence and as demonstrating a striking contrast to the court's tendency to create a broad scope for Article 10, paragraph 1, combined with the demand under Article 10, paragraph 2, for particularly weighty justification for interference with speech of political import broadly conceived. So this jurisprudence on extremist speech is open to attack as allowing political expression to be abrogated too readily. So the argument is for applying the Article 10, paragraph 2 test rather than relying on Article 17 to speech with political content that's not merely abusive towards certain groups or incites violence. In applying those Article 10, paragraph 2 tests to extreme speech, it may be argued on the basis of the key instrumental justification to further the self-government rationale that some speech of far-right, secular or faith-based groups directly aimed at attacking democracy or democratic values fails to satisfy the aim in question of enhancing audience participation in the democratic process. In particular, if the speech is not part of a plural activity, in other words, it can't be challenged or isn't challenged, and especially when aimed at children or young people, for example, in schools or colleges, the impact on the audience could ultimately be of an anti-democratic tendency, inhibiting, not enhancing, their participation in the democratic process. Restrictions on such speech from various groups aimed at non-participation in that democratic process could then be defended under paragraph 2. So in conclusion, then, I've discussed a range of restrictions on audience rights to receive information and ideas deployed to seek to ensure their quality and to have an influence on the audience's responses. Restriction on the expression of certain views in some settings, if presented without challenge, can be defended, but as I've indicated, in a number of circumstances, it would be preferable to rely on Article 10, paragraph 2, rather than Article 17. A full application of the tests under Article 10, paragraph 2 to interference with non-violent extremist expression, confining reliance on Article 17 more clearly to expressions of violent extremism, would avoid setting aside substantial principles and safeguards characteristic of the European speech protective framework, while also bringing greater methodological consistency to the policing of the divide between Articles 17 and 10. However, bans on political advertising or on spreading misinformation about politicians or with possible political content may run the risk of failing to satisfy the demands of proportionality due to concession of quite a wide margin, while apparently seeking to serve the aim of enhancing the quality of the democratic process. That's partly because consensus analysis has in some instances influenced the court's thinking on these matters, as seen, for example, in animal defenders. Where such analysis has enabled a broader margin to be conceded, the proportionality analysis has not been strict. The court's position can be compared with that of the Inter-American Court of Human Rights, which tends to eschew consensus analysis and recently found, in a completely different context, that of denial of same-sex marriage in 2017, that consensus analysis could not influence its decision. Just 5 states subject to the court's jurisdiction had introduced equal marriage at that point. If the Strasbourg Court's approach to same-sex marriage or political expression based on consensus analysis had been followed, it might appear, given that context, that there was an even stronger case for the Inter-American Court to approach the issue of rights of same-sex couples to marry with caution. But the court refused to take that stance. The Inter-American Court found that the American Convention on Human Rights should encompass same-sex marriage in accordance with the object and purpose of the Convention, adopting an evolutive approach. In coming to the conclusion that the American Convention does provide for same-sex marriage, the court explicitly stated that the lack of consensus among the member states did not provide a valid ground for refusing to recognize the equal right to marry under the Convention. Those findings in the context of the fundamental right to non-discrimination clearly could also be applied to the fundamental right of audiences to receive information and ideas, allowing engagement with political debate and the political process. If consensus analysis had not played a part in animal defenders, the margin conceded would have been narrower. And therefore, although the matter had been debated extensively within both the political and judicial processes in the UK, the court would more readily have reached its own conclusion on proportionality, taking a stricter stance as to its demands.